or I will maybe confuse you more, but I will attempt at least. Are there anyone that has anything that they want to ask me? Nothing. I see that we are only 40 still. So
yes, please, ma'am. When are we getting the slides?
Oh, guys, she just said it now. She'll send it to Zukiswa.
Sorry?
I'm going to send it to her tonight or tomorrow.
Oh, okay. Sorry, I
over the
just joined
weekend.
now.
Oh, no,
All
it's fine. It's fine. She will send it to you. I will tell her to do it as soon as possible, but I don't have any control as to when she's going to send it. But she couldn't send it yet because she doesn't have it yet. It's still with me.
No, it's fine. Okay. Thank you.
No problem. Any other questions? None. So let's proceed and see how we get on with tonight's class. Right. We spoke last night. Remember, we are now busy with applications, and I said how the court will deal with an application. If there appears to be there's a sorry, just to move away from this for a moment. Somebody's microphone is on and it is disturbing. Okay, thank you. Right. So when you have chosen the incorrect procedure because you did not foresee that there was a real dispute of fact. Last night we looked at all the 4 possibilities that the court may do. First, they can dismiss it, or they can send refer a certain part of the application for oral evidence, or they can refer the whole application to a trial. And I said this is all on application from one of the parties, or they can deal with it in terms of the Plascon-Evans rule, and then I've explained to you what the Plascon-Evans rule is. It's a very easy rule to remember. You look at the undisputed facts and you see what is not in dispute, because the court deals with applications on the undisputed facts. So can that person who's making this noise please just mute your microphone, please? Okay, thank you. Yes, then the court will look at the undisputed fact and what does the respondent say further. And if the court is satisfied that the respondent, what he says further, does not take his case any further, that the applicant is actually entitled to the relief that they are requesting, the court will give the order. Okay, that's how the court deals with disputes of fact that appears from the papers. And then we looked at the notice of motion, and now we looked also at the founding affidavit. And I told you that if the information in the founding affidavit is not in the personal knowledge of the deponent, that is the person who makes the founding affidavit, who talks in the founding affidavit, sorry, that we call him the deponent. He deposes to an affidavit. Just be careful that you use the correct language when you appear in court. And then I said, to cure the hearsay quality of that evidence, if the deponent is going to refer to something that someone else told him, that's hearsay evidence. And we know the court can only consider evidence. So to cure that, that person must make a confirmatory affidavit, right? That is where we ended last night. So I will now proceed from there. Right. The answering affidavit, now, just like the plea, the answering affidavit to each and every allegation in the founding affidavit, you must then address that, right? So all the allegations in the founding affidavit must be addressed, either admitted or denied or confessed and avoid, right? And if you deny something, remember, we're not going to have the opportunity to bring a witness to give evidence. Substantiate your denials. Don't just make a bare denial. Tell the court why you are denying any allegation in the founding affidavit, right? And also set out your defense and the facts that support your defense. So what people would usually do is, yes, you are supposed to be seeing slides. Are you not seeing the presentation? Okay, let me see.
can't see any slides.
Is everybody not seeing it?
Yeah,
Sorry
I'm
for
also
that.
not seeing
No.
it.
Yeah, I see that you can't see it. Sorry.
Nothing.
Can you see it now?
Still not.
Yes, now
On my
yes,
side,
we can
it's
see.
yes, requirements for pay.
Yeah, the requirements for papers. You can see it now. Sorry, thanks for bringing that to my attention. Okay, so the answering affidavit, all the allegations must be addressed. And if you are going to deny any of the allegations, then it must be substantiated, right? And you set out your defense and the facts that support your defense. Now, how people usually deal with that is before they start to address each and every paragraph, and you do it exactly the same like you did in the plea. You will say at paragraph 1, and then you will say, I deny this, because remember, it's a person who's speaking. So, but before you get to that, you can tell the court what your defense is, and you can give a bit of background and tell the court your side of the story before you actually address the allegations as set out in the founding affidavit. Okay, that's usually how people do it. So set out your defense and your facts that support it. And then if it's not included in your answers to the allegations, right? And then the applicant files a replying affidavit. Now remember, in the replying affidavit, you cannot bolster evidence. You are limited to response where necessary to the factual allegations by the respondent in the answering affidavit. Right. Exceptions to the general rules. I've already told you about ex parte applications. That is where there's only one party, and that party is bringing an application to court for relief. There's no respondent, right? Like, for example, when you are going to apply to be admitted and enrolled as an attorney of the High Court, that is going to be an ex parte application. There's also other examples of ex parte applications, like, for example, an application for the appointment of a curator, the application to have somebody declared dead. So there are many others also where it's ex parte applications where there is no opponent, right? So that is the ex parte application. And I've already told you that you use the short form. There are two forms of notice of motions. They are all forms that is attached to the uniform rules. So form 2 is the short form and form 2A is the long form. Okay, so if there's no opponent, then you would use form 2. And in the supporting affidavit to the ex parte application, you would set out all the material facts to support you getting the relief that you're requesting. For example, if you're applying to be admitted as an attorney, you will set out the Legal Practice Act says that you must be a fit and proper person, that you must have completed articles, and then you must attach some affidavit from your principal, and that if you've done this course, that you've passed it, and therefore you could only do a year's articles. The other, what is the other requirement? Oh, that you passed the board exams and results. All of that is attached. Your ID document, when you say who you are, all of that is attached to the application to support the court in then finding that you've met all the requirements and they can give the order. Right. Okay, now I've got here Rule Nisi, now you, or Rule Nizai, however you say it. This, now I have it under ex parte applications because you would sometimes hear when people are speaking, they say they bring an application ex parte, but that is not an ex parte application where there's only one party. When an applicant brings an application ex parte, it's usually an urgent application where the respondent cannot be before court because of time. And because the respondent cannot be before court because of time, he brings it without the applicant. Yes, can you mute your mic, please? So that person whose microphone is on. Thank you. Yes. So the respondent would not be able to go to court, and then you would hear people would say it was brought ex parte. That means without the respondent having been in court. But there is a respondent, and this is usually with urgent applications that is so very urgent that you can't wait for the respondent to be ready to go to court. So you bring it without him being present. But now you're going to wonder, but what about the audi alteram partem principle? Because I said that is one of the rules that underlie our law, and it's one of the rules of natural justice. I don't know why the slides keep disappearing. Thanks for telling me. Yeah, do you see it again?
Yes, we
Every
can now.
time I go and I see who's in the classroom, then the slides disappear. So maybe I should just remain here. I want to see if there's hands up or anything, but it's fine. Right. So I was telling you about
Yes,
one of
my
the
hand is up, ma'am.
difference. Hey,
My
can
hand
you
is up,
hear?
ma'am.
Okay. Yes, please ask.
What happens, ma'am, in the admission application in the event that the LPC wishes to oppose my admission? Do they then become a respondent?
No. What happens in practice is part of the application. You have to deliver a copy of your application to the LPC. They then have people that will go through your application to see that you've met all the requirements. If they have a problem that you didn't meet all the requirements or that something is outstanding, they will call you and ask you to remove the matter from the roll because you must still comply or you must still do something more. And if that is the case, they will let you know so that you can remove it from the roll. If you insist in keeping it on the roll, they will actually send somebody, a representative, to be there to tell the court that they object. Because when a person is admitted as an attorney, one of the submissions that the counsel will make is when he gets up, he will say, "My Lord, I appear on behalf of the applicant in his application for admission as an attorney. Mr. So-and-so is in court and he is willing to take the oath." Then and one of the things that you have to say is the Legal Practice Council have no objection to him being admitted as an attorney. So they can object. So if to make that submission, they must have seen the papers and must have said, okay, you can go ahead with that. If they say, no, don't go ahead, and you insist on keeping it on the roll, they would have sent somebody there because they would have checked and they would have told the court that, look, they have an objection because you didn't meet, and then the court will remove it from the roll. So that is
Thank
what
you, ma'am.
happened. They don't become a respondent. It is still an ex parte application with only one party. But they do look at your application to see that you've met all the requirements. And they will say, they might even inform the court that they have an objection to you being admitted. They might even send a note to the judge president, this matter is on the roll, but we object because, and this matter should be removed. They might even do that. But they will inform you and they won't embarrass you in open court. But if you insist on keeping it on the roll and going to court and try and fight there, then things will come out. Like, for example,
Thank you.
must, to be admitted as an attorney, one of the requirements is that you must be a fit and proper person, right? Now, a fit and proper person, what is that? Some people will say it's a person who don't have a criminal record and that. But I have seen personally that people with criminal records have been admitted as legal practitioners, because in your application, if you have a criminal record for whatever reason, you must just explain that you're now rehabilitated, what you have done since that, and all of that. And if the LPC is satisfied, they will say, okay, we don't have an objection. So that's not a bar to you being a legal practitioner, because I have seen people with criminal being admitted as legal practitioners. It's just, what did you do afterwards? And you must come forward and say that in your application, give everything. And they might ask you, did you appeal if you're going to insist that you were innocent and wrongly convicted, they will ask, did you appeal? And then they will ask more information. So in that case, they will object to it going on the roll immediately, and then you must give them more information. So it's best to give them all the information and be transparent right at the beginning. Set out everything in your founding affidavit. Okay, yeah. Now, I was talking, are there any more questions? Because I don't want to go to the screen where I can see whose hands are up. Just tell me if your hand is up from Hinsworth. Okay. I was talking about when you bring an application ex parte when the respondent cannot be there because it is so very urgent. Now we're going to do urgent applications, right? And I'm sure all of you have heard of urgent applications. So when the respondent can't be there, sometimes the applicant is alone in court and he gets his order. But in that case, he gets an order with a return date. That is what is referred to as a rule nisi. Right? So in other divisions, except for Gauteng, they have the rule nisi where you ask, and what the rule nisi means is that the person, the respondent, on the return date, come to court, and then he can tell the court why the interim order that was granted in his absence should not be made a final order. Okay, or yeah, so that is the audi alteram partem being applied. He gets an opportunity to come to court because the court, if the respondent is not there, will only grant interim relief and not final relief. Right? And we do know that the requirements for interim relief and for final relief is different. So you must make out a case for interim relief if you are appearing in an urgent application where the respondent is not in court. Sometimes the respondent is represented in court by counsel or by an attorney, but he's not there in the sense that his papers have not been concluded and there's no evidence before the court to consider on his behalf. So he's just there to observe, and the court may give an interim order even though he's not there, or may give an opportunity depending on the urgency of the matter. Right.
Hello.
So yes, is there a question?
Yeah, ma'am. The rule nisi, is that only applicable to ex parte applications? That's my first question.
No, not only to ex parte applications. This is where I'm dealing with it. But you will see in applications for liquidation and sequestration, the court it's two in two parts that you do that application. You do the first application for provisional sequestration or provisional liquidation, and then the court also order a rule nisi. That is when you have to come, where the parties have to return to court, and where the court will then decide whether the order that is requested should be made final. So it's not only for ex parte applications. There are other cases where you have a return date.
Okay, in case of an urgent interdict, an application for an interdict, urgent interdict, is an ex parte application in order, and will rule nisi apply in that particular case?
Well, it depends on where you are bringing it. Like, for instance, in Gauteng, they don't have the rule nisi anymore. They have a Part A and a Part B in their applications. So basically, Part A would be for the interim relief and Part B would be for the final relief. And they would ask, you would ask, it comes down to the same, because you would ask that Part A, the order in Part A is given until Part B is being dealt with, until the final relief is given. But yes, it is when there is no, but the rule nisi is to give the respondent an opportunity to come to court, to tell the court why the relief that the court has granted on an interim basis should not be made final. And the respondent does not have to wait until the date set out in the rule nisi, because they will give you a date. If the respondent wants to be in court earlier, he can anticipate an earlier court date, that is 24 hours after he has received the order, the interim order. He can be back in court and to tell the court, look, this interim order should never have been granted, and his side of the story, set his side of the case out, and then the court can make a decision then.
And the part A you referred to in Gauteng, is that also an ex parte?
That is for interim relief, and then part B would be for final relief. And the interim relief is usually dependent on yeah, it's usually pending the final relief.
Is that also an ex parte application?
No, no, usually it is not. Look, in the practice directives of all the divisions, even though I say you can bring an application ex parte if it is very urgent, the courts actually require that you, in the practice directions, that you at least inform the respondent that you are now going to court. Even if it is by telephone, by email, to say, look, I'm going to court tonight, I'm going to be in court. And it depends on the urgency of the matter. You must give the respondent at least a time to get his papers and his facts before court. But if that is now really impossible, then only it's an ex parte. But in that case, you should have phoned them, and they can be present, but their affidavits will not be present, depending on the degree of urgency of the matter.
All right, and lastly, all urgent applications given some form of interim relief, then giving the opportunity to the respondent to hear his side of the story at some stage.
No, not just at some stage. In urgent applications, when look, there are different degrees of urgency. So the respondent may have had an opportunity to state his side of the case, and then the court don't grant interim relief, but then the court can grant final relief at an urgent application if the court hears both sides of the case.
Okay, thank you.
Okay. Right. Yes, and I've already told you about okay, are there any more questions on that issue? We're going to do urgent applications, but I'm just at this stage want to know if there are any more questions before I move on. The interlocutory applications, I've told you about that. That is applications that are ancillary to a main action or main applications that is already pending in the court, and it is to deal with issues so that that main application can run smoothly, and any side issues that needs attention and the intervention of a court to order parties to perform in a certain way, that is when you bring interlocutory applications. And I think I already mentioned to you that they have a dedicated court in Gauteng that does only interlocutory applications. In other divisions, interlocutory applications is done in the normal unopposed motion court. But yeah, because there are so many, they have an interlocutory applications court in Gauteng. Right. And yeah, yes, is there a question? You may proceed, sir. I'm going to try and see who it is. I hope I don't lose. Okay, yes, who is somebody asking a question? I can hear a sound. We are still only 40 people. I think people thought this Friday night classes is not on.
Actually not. I see 114 so far.
Oh, now how come I see only 40?
I don't know. On my side, I see
So mine is not right. Okay, no, I'm happy. Yes, is there a question? No, I may proceed then. Right. Urgent applications. Now, Rule 6, I told you Rule 6 deals with applications, right? So urgent applications is dealt with in terms of Rule 6.12. Now, when you are bringing an urgent application, this means that you are not going to wait for the normal times for a matter to be set down on the roll. You are not going to file a notice of motion with an affidavit and say you have 5 days in which to give a notice of intention to oppose and then 15 days in which to file an answering affidavit. You're not going to do that because you feel that your matter is urgent, right? So if you are doing that, then the first prayer that you would ask for, that you would pray for in the notice of motion would be that you ask the court to condone you not complying with that rules, the rules of forms and service, right? So you would ask the court probably for the abridgment of the prescribed times, or from the departure from usual filing and the court sitting times, if you're going to bring it outside of the court sitting times, which is the normal court day. You can bring urgent applications in the middle of the night. You can bring it on weekends. You ask the court from the departure from the obligation to serve the notice on the respondent, if that is the scenario, or from the prescribed form for the notice of motion. Sometimes a matter is so urgent that the applicant's legal practitioners don't even have time to draft papers. And then you just go to court, with the applicant will under oath tell the judge what the story is. You have your draft order so that the order can be given immediately. Sometimes it is that urgent, but it depends on the urgency, right? The degrees of urgency will dictate what the degrees of relaxation of the rules are, right? Now, usually the court will ask you, where is the burning house? That must be now, the fire that must be extinguished. Where is that? Why must I come to court after hours? Is the house burning? Can we wait for tomorrow? Can we wait maybe for next week? That is going to be the court's attitude, right? So the degrees of urgency will dictate what the degrees of relaxation is. If life, liberty, or bodily integrity is at stake, usually it is very urgent. Commercial interest, not so urgent, because you can always claim if the damages that you're going to suffer is going to be money or monetary, or with damages, with the claim for damages, you can be put back in that position. Then that is not so very urgent. And then also, you should not create your own urgency. The court won't look kindly on you if you create your own urgency. What I mean when I say create your own urgency is that you know something is going to happen. You know in advance that at a certain point next month, something is going to happen. Now you wait the day before it's going to happen, and you come to court and you try and stop that from happening. That is you creating your own urgency, and the court will strike it from the roll, right? And it depends on life, liberty, or bodily integrity. If that is at stake, the court might entertain it as an urgent application. So in your notice of motion for an urgent application, the first prayer is for an order dispensing with the forms and service provided for in the rules, and directing that the matter be heard as one of urgency in terms of Rule 612. So the prayer is for the condoning the non-compliance with the rules, and then whatever relief it is that you are requiring, and then asking for a return date. That is now if the respondent is not there. Now the applicant chooses the time. Look, if you're going to bring it without the respondent getting an opportunity to come to court, you decide today, your client comes to you today, and you need to go to court today still. And obviously, and you draft the papers, there's no chance to wait for the respondent. But if your client comes to you today and something is going to happen next week, you can still tell the respondent in the notice of motion, which can be served then by the attorneys himself, his messenger. They must just make an affidavit of service, because you're not going to comply by letting with the rules that the sheriff must go and serve. You're going to ask the court to condone your non-compliance with that rule. Right, so then you can ask, you can shorten the periods. You can say, if you're going to oppose, let me know by tomorrow at 12 o'clock, and then the next day at 2 o'clock, file your answering affidavit. So you can shorten the times depending on when it's going to be heard in court. You can decide for that, so that the respondent can still be in court. And you can decide what is then based on the urgency, because at some point in time, you're going to have to stand up in court and explain to the court why you said that is sufficient time for the respondent to do that, and why he couldn't get 2 more days or whatever. Right, so in the affidavit, one of the most important aspects that you need to address in the founding affidavit is the urgency. Because the first thing that is going to happen, how it happens is there is a registrar on duty for the urgent role. So that is the person that you would call. You would get the phone number of the duty registrar, and they would know which judges is on the urgent role for that week. So you would get hold of the registrar. They would ask you why is it urgent? This is now if you're not going to wait for a normal court day, if it's outside of court hours. And then they would want to know why is it urgent, because the first thing that the judge would want to know is why is it urgent? Why can't it wait? And then you have to explain it. So in your papers, you are also going to set out the reasons for urgency and why you can't wait for redress in due course, like for your normal place on the roll, like everybody else. Why must you be given an opportunity to cut the line and go in front of everybody else? So you have to make out that case before you make out your case, because the court will only entertain an urgent application on the urgent role if the court is satisfied that the matter is indeed urgent. So the respondent might come to court and might just argue that the matter is not urgent and might set out the reasons why it's not urgent. And then for that reason, the matter can be struck from the urgent role and then put on the normal court role. Okay, or why it is not so very urgent. So it depends on the facts of each case. Right. So in the affidavit, you must set out the circumstances which render the matter urgent and the reasons why the applicant claimed that he or she could not be afforded redress at a hearing in due course. Examples of urgent applications, just some of you are wondering when you would bring an urgent application. If somebody is taking a child out of the country and they're at the airport, the airport, they would need a court order to stop a person from getting onto a plane. So that would be very urgent. But if depending on when you found out this was going to happen, like, yeah, if it's now parents and the one parent wants to take the child out of the country. Another kind of urgent application that comes to mind is burial. If a person dies, and sometimes it so happens that because of different religions, that different family members would want to bury the person in a certain way, and especially Muslim and Christian. I once had an application where the person was Muslim before, and then he married a Christian woman afterwards. And when this person died, his wife wanted to bury him in accordance with the funeral in church, but his children, who were adult children, wanted to bury him according to Muslim rites. So then they came to court because they couldn't come to an agreement, and the court had to give a decision. So that is very urgent, because we know that in terms of Islam, you must be buried, I think, on the day or the next day as soon as possible. So just to illustrate what would be very urgent. Right. So that's urgent applications. And interdicts is not usually an urgent application, but mostly interdicts are urgent applications. And the common scenario is, in order to protect your client's right, you must either ask someone or oblige someone to take certain action, that is by means of a mandatory interdict, which is called a mandamus if the action required is part of the duties of a state official, or oblige someone to refrain from acting in a certain way. That is a prohibitory interdict, right? And usually the matter is so urgent that the legal vehicle you will use is an urgent ex parte application that would lead to first the interim relief, and we do know that the requirements for interim relief is a prima facie right, a well-grounded apprehension of irreparable harm if the interim relief is not granted and the ultimate relief is granted, and then that the balance of convenience favors the granting of the relief, and that you have no alternative remedy. Right. And then on the return day, in order for the applicant to be successful in making the interim order a final order, he must establish a clear right that an injury actually committed or about to be committed, and then no alternative relief. So when you're going to draft an urgent application, you would cite the parties, why the court has jurisdiction, and then you will have a paragraph where you will discuss, or a heading where you will discuss urgency, however many paragraphs you need to discuss why the matter is urgent. And then you will cover each and every of these requirements. You will say what the right is. What is the well-grounded apprehension of irreparable harm if it's not granted? And you will discuss that the balance of convenience favors the applicant and that no other alternative remedies. You've done everything that you could to stop this, and the court is your last resort. And then you would have made out your case. So you're telling the court the story, but you see that you meet the requirements. And when you argue this, and this is all contained in cases. This is the requirements for an interim relief. Like I can tell you now, the case there, Set Logolo, but you would know the cases you've studied recently. You would know the substantive law. And yeah, are there any questions on urgent applications? I can also inform you now that if you are looking for precedents, for nice precedents, if you're doing your articles and you need to draft, if you look at the practice directives of the South Gauteng High Court, at the back of the South Gauteng High Court, there's a lot of precedents as to what draft orders should look like for certain applications. So please look at that, and it can give you, it's a good guidance, and it's something nice to have. Okay. I heard somebody, is there a question?
Yes. Urgent application cost. Yes. Can I go ahead, Advocate?
Yes, you may. You may go ahead, sir.
Yeah, the costs regarding urgent application, are they the same as an ordinary trial?
The cost. Yes, it would be this. Look, the cost, you mean the cost that if you are successful, the cost that the court allows, or are you talking about what the attorneys would charge their clients?
I'm talking about both, yes.
Okay, usually if you're bringing an urgent application, some I know some counsel charge a bit more if it's out of court hours and if they have to work like more. That I know, but the cost would remain the same for what you can charge for the work done if you are the successful litigant and you are awarded the costs. That is in terms of the High Court tariffs. They don't have separate tariffs for urgent application. It is the same tariffs.
Thank you, Advocate. Thank you.
Okay, but the lawyers charge more for bringing an urgent application, because if they have to sit through the night or the weekend or whatever to draft papers and to do everything in a hurry, they do charge more for that. But like I told you earlier on, that is a contract with your client. And if the client agrees to pay, then that is fine. It's a contract that you enter into with your client.
Advocate, you indicated that urgent applications can be brought 24/7. Firstly,
oh, yes, sir. I can't hear. I indicated.
That
there's a sound.
Oh,
yes.
Can you hear me now?
I can hear you.
Oh, you indicated that urgent applications can be brought 24/7. Now, have you come across instances where the court sits at 1 o'clock in the morning to hear an urgent application?
Yes.
Like 1 o'clock on a Sunday morning. So is that not abnormal?
Yes.
Is it normal? Yeah. Okay.
Yes, the court comes out the court will come out to the court, and that happened now pre-COVID. I think now probably you could do it online virtually, but usually the court would have come to the court building, or alternatively you could have gone to the judge's house, but the judge would come out. And if a judge is on urgent duty, like I say, they get rotated and they get urgent duties like once every 2 months or 3 months, depending on how big the division is. So for 1 week in that time, they would be on urgent duty and they know they must be available. I don't know if you watched the interviews the last time around for judges, where this one judge had a matter at Spur. There was a huge thing, memes about it. That was an urgent application and she didn't hear it at her house and she arranged with the people to hear her, to come to Spur in Benoni. Don't know if some of you heard about that. But yes, judges do come out. Hey? Excuse me?
Yes, we saw it, advocate. It cost
Yes, that was an urgent application.
Yes.
But these days with us being comfortable in litigating on Teams platforms, virtual platforms, I'm sure it can be done where everybody's in the attorney's office and the judge is probably at his house and nobody has to drive through to court, because that is, I think that judge also said it was dangerous to drive to court at that time. So they could meet on an online platform and do urgent applications, because that is what we've done during COVID. So for that same reasons, the danger element and all of that, I'm sure it can still be done. But yes, your question, to answer your question, yes, many cases are heard in the middle of the night, especially remember in the past when newspapers were going to publish defamatory information and you want to stop, then people go in the middle of the night to court to stop the newspapers from distributing the newspapers with defamatory information on it. So yeah, then the court will come out, would have come out and hear the application.
Thank you.
Give
Thank
the
you.
order. Okay. Let's move on. Right, okay, so this is an urgent in the note. You will probably see this when you I would have asked you now if we were in each other's presence that you must draft this application, and this is in, I'm just going to tell you where the question is, so that if you do get the slides, then you know what the answer is. Oh, just give me a moment. Okay, yeah. On page 206, right, of your manual, there's a self-assessment question. And the question is the following. Your client is Mr. F. Brown, a farmer who used a road through the neighbor's farm, Mr. S. Chicks, for the past 5 years to get access to town. On the Monday morning, your client discovers that Mr. S. Chicks has put a gate on the road and locked it. Mr. F. Brown urgently needs to deliver stock to town, and if he cannot, he will lose a big contract. You advise your client that he can bring an urgent application. Draft the notice of motion and supporting affidavit, include all headings, and make up your own facts when necessary. So that is the self-assessment question A on page 206 of your manual. And I would have asked you, and then I put up how you would draft it. So this is now the notice of motion. Kindly take notice that application will be made on behalf of the applicant and all of that, and that this application be treated as an urgent application, and that the above honorable court dispense with the normal rules, that the respondent be ordered to give access to the applicant to the road described, and then the road is described. Alternatively, that the sheriff of the honorable court be authorized to give access to the applicant with whatever means necessary. And then that the respondent be ordered to pay the costs, and then further and or alternative relief. So that would be in the notice of motion of this, right? That is what that is about. Kindly take further notice that the affidavit of Mr. F. Brown will be used in support thereof. And then I didn't include information that you have to include in the form 2A is if you intend to oppose, and then you would give a time how long he has to indicate that he's going to oppose, and how long he's going to have to file his answering affidavit, and you would shorten it because this is now an example of an urgent application. And then you would, for the founding affidavit, I don't have the full founding affidavit, but I have headings. So the headings would look like this. I, the undersigned, I gave Fred Brown to hereby make oath and say that I am the applicant, an adult male farmer residing at Chickenican, Devil Road, Malmesbury. The facts contained herein are both true and correct and fall within my personal knowledge, unless the content indicates otherwise. Where I make legal submissions, I do this on legal advice, which I verily believe to be true and correct. Right. Just as an aside, I recently read an article where it said you should be careful to say this, but many people say this in affidavits. For those of you who have read affidavits, this one about where I make legal submissions, I do so on the legal advice, which I verily believe to be true and correct. Because this article addressed this and said, when you do this, you are actually waiving the privilege, the legal client privilege, because you are saying, I'm going to tell you what my attorney told me. So you're waiving whatever he has told you, you're waiving all that rights, just as an aside. I thought it was interesting. The first respondent, you will then identify him, is Mr. S. Chicks, an adult male farmer. And then you would talk about the jurisdiction, what is the factual allegations, what is the urgency of the matter, and then the requirements for an interdict. You would, what is the right that you have? In this case, it would be the right of way over the property and how long it existed and all of that. If it's a servitude, you would set that out. What is the injury? The gate was locked. What, you have no alternative remedy. Maybe you've spoken to the person and they didn't want to open the gate, so the court is the only relief. And that is how you would do that application. Do I have any questions? None.
Advocate?
Oh, yes. Yes, okay.
Yeah, not necessarily a question. I think it's just an observation.
Okay.
I think your other slide, if you go on that, on the notice, on the summons. I think, sorry, not
this one.
Yeah, I think I saw that you're saying that you just want to dispense with the.
I didn't specify what I want to dispense with, yes, because it depends on what you're going to answer in your answer. That's why I put them with the normal rules. So I just generalized that the normal rules is not going to be complied with.
Yes.
And people sometimes do this because, but then there's many rules. It's a rule of service. Maybe they didn't use the forms. It's the times that they are bridging. So you would say what it is that you are bridging.
Okay,
yes.
because
but there's nothing wrong with just saying it like this also.
Okay, because I see on the study guide it says a court may dispense with the forms and the service.
Yeah.
So basically, we'll be asking for the court to dispense with the forms and the service.
Yeah, yeah.
Okay.
But not if you're going to use the correct forms. If you're going to use form 2A, then you don't have to ask the court to dispense with that. That's why I say it depends on what you're going to. And if you're going to have the sheriff serve it, because you're not going to bring it on the same day, but maybe the next week, and you're going to ask the sheriff to serve it, then the forms of service, you also don't have to ask for condemnation. You only ask for condemnation for those rules that you want to relax. And it would be maybe the rules for the times, abridgment of the times, because you would want the respondent to give an answering affidavit like within 2 days.
Yes, so. service rules, yes.
Yeah.
Thank you.
Yeah.
Thank you, Advocate.
Okay. Fine. Right, so that is are there any other questions on urgent applications before I move away from it? None? Okay. Okay, I see people are having problems logging on. No, Mohale, yes, the South Gauteng High Court practice directives are available online. The precedence is like part of that. It's at the back of it, but it is available online. You can just put in Gauteng High Court practice directives, and you will see it. In fact, all the courts have the practice directives. It's the way available online. You'll find it on any of the bar websites or even on the attorneys' websites. right? And I see people have problems in logging on. I don't know how to assist there. Right, so another specific application that we must look at is the interpleader. Now, I'm sure you've done interpleader with Magistrates Court practice. Am I correct? Have you done interpleader? Can somebody just indicate? Okay, I'm going to ask someone. Nazir, did you do interpleader? Nazir, are you there? Okay, who can I ask? Rosalind, did you do interpleader? Nobody's answering me. I need to know your level of what you know before I start. Yes?
I don't think we have done interpleader.
But it's
No.
part of match code. Okay, let me then just do
Yeah, we
it.
would have in there, but we didn't do the High Court one.
So you did no, I'm not talking about the High Court one. I'm talking about interpleader. The procedure is the same in all the courts. Did you do it in the?
I can't remember, but we probably did.
Okay. Right. So you won't be able to tell me what an interpleader is. Right. Okay. So an interpleader. Yeah. Rule 58 of the uniform rules. Right. This is what the rule says. A person under liability in respect of which he or she is or expects to be sued by two or more parties making adverse claims may deliver interpleader notice, an interpleader notice with an affidavit to the claimants. Right? So basically that is what Rule 48 says. Let me just quickly go to Rule 48 and to pull up Rule 48.
Isn't it Rule 58?
58, yes. Sorry, not 48. I just saw 58 is, it's 58. I have it as 58. I don't know why.
I think the switch on my mic when you ask the question.
Do you want to ask a question?
No. When you ask it, you knew about moving.
Oh, okay, fine. Where any person in this rule called the applicant alleges that he is under liability in respect of which he or she expects to be sued by two or more people making adverse claim. In this rule referred to as the claimants in respect thereto, the applicant may deliver a notice in terms of this rule called an interpleader notice to the claimants. In regard to conflicting claims with respect to property attached in execution, the sheriff shall have the rights of an applicant and the creditors shall have the rights of a claimant. So basically what this says is the following. If you expect to be sued by two people, two or more people for the same thing, and it happens if you don't know who is now the rightful person that is entitled to sue you for this thing, then you would use this procedure that you will serve an interpleader notice, right? Now, there's an example of an interpleader in your notes. Let me just explain to you with that example, then you would understand. The farmer, and I might not be 100% correct with the facts, but this is how I explain it to you. The farmer wanted to sell his farm, right? So he invites estate agents to come and look. This estate agent come and they look and they say, fine, we'll find you a buyer. Weeks pass and then the estate agent comes back and he says, I found you a buyer. This farm gets sold. Right. Now time comes for the farmer to pay the estate agents. This person who came with a buyer at the first time when he was there at the farmer's farm, he was working for one estate agent and then he changed jobs and he was employed by another estate agency. So both of these estate agency now wanted to claim that commission. The farmer knows he owes the commission to someone. He just don't know who. And he knows if he pays the wrong person, the other one will have a legal claim against him. So to avoid that, he serves an interpleader. So in the match court, I think it would have been explained to you, I don't know, with the sheriff. When the sheriff comes and he attaches, with a warrant of execution, he attaches property that must be sold, property that belonged to a judgment debtor, that must be sold to pay the judgment creditor. And he attaches incorrect property or property that does not belong to the judgment debtor. He comes to the house where the judgment debtor lives and he just writes up stuff and attaches stuff, and then maybe there's a car in the garage and the car belongs to the parent of the person. It's a student, and then the parent wants his car back because he says, no, my car can't be sold for the debts of this person because that is my car. Then the sheriff now knows that the creditor, the one who got the judgment, has a claim for that because it's prima facie belongs to the person where it was from, or the owner of it has a claim for it as the owner. So the sheriff then serves an interpleader on both of them, and then the court will have to decide who is the rightful owner and who, whether it belongs to the judgment creditor or whether it belongs to the parent. That is the example that they usually use in match court. So in this case, these two estate agencies will have to go to court, and the court will then determine who is the rightful person that is entitled to the commission. So in this case, the farmer will serve an interpleader, right? That is what the rule says, rules of Jake. Yeah. Is there a question?
Yeah,
Yes.
So the interpleader is an application. So the farmer in this case serves an interpleader. Who goes to
Interpleader, it's like a notice, an interpleader notice. There's an example of an interpleader notice that you will serve. Yes, the farmer will serve it, yes. Because he is remember the rule said the person under liability in respect of which he or she expects to be sued by two or more parties. So he is under liability, but he expects that two people can claim from him, and he doesn't know which of those two people are the actual people. There's an example of an interpleader notice on page 262. Yes, you can go ahead with your question. Sorry, I interrupted you. Nazir, did you want to ask something?
Yeah, so the farmer, and I'll just use a specific example, he serves the interpleader, but this is all done on papers again because this is an application.
Yeah, he serves an interpleader notice, yes, and then he does an affidavit, yes. But when they go to court, the two claimants, then they will have to give evidence in court. Because the court must determine then who is the rightful owner of the property.
Okay, so the farmer himself is not involved in this. I mean,
No,
those two
I'm going to get to that, yes. He's not involved because he's saying, look, I know I am under liability to give this money. I just don't know who is the rightful person that I should give it to, and I don't want to risk giving it to the wrong person. Right. So in the notice, I'm going to go ahead, and maybe your question will be answered by further participation. Let me know at the end if you are satisfied, or then we can discuss further. So in the notice, thanks. In the notice, the party must state the nature of the liability or claim, which is the subject matter of the dispute. He must call upon the claimants, this is now the two people who are both claiming, to deliver particulars within a time period indicated, and it's usually not less than 15 days from the date of service, and state that on a further stated date, not less than 50 days from the previous date, the applicant will apply to court for its decision as to his or her liability or validity of the respective claims. Right, and in the affidavit by the applicant that goes with the notice, he must set out facts and state that he or she claims no interest in the subject matter in dispute other than for charges and costs, that he does not collude with any of the claimants, and that he's willing to deal with the subject matter in dispute as the court directs. So he actually just place it in the hands of the court, the matter. And he says, whatever the court decide, I will comply. On delivery of the notice, he must, if the claim relates to money, pay the money to the registrar. If the claim relates to a thing which can be delivered, tender that to the registrar. And if the claim relates to immovable property, he place the deeds in possession of the registrar and also give an undertaking that he will sign any forms and stuff that he must in terms of the court order. Right. That is basically what it is. I don't know if you are satisfied. Was it Nazir?
Yeah, very satisfied, very clear. Thank you.
Okay. Sure. So that is how it is. And then in court, when the interpleader is heard, the court will call those two claimants and they must give evidence, provide evidence as to how they feel they are entitled to this money or whatever thing or whatever the subject.
Does this turn out to be oral hearing? This is not decided on the papers then, is it?
Look, though, I've attended interpleader where it was an oral hearing where the court actually heard oral evidence. No, but the one that I've attended, and that was only one right at the beginning of my practice, it was in the match court, but the court actually entertained oral evidence where the parties had to give evidence as to why they believe that they are the rightful person that should be given.
Okay,
that is the owner, or that should be given the money that should be paid. That is the person under liability. Yeah, that is to who the person is liable. Yeah, the applicant is liable. Yes. So in the magistrate's court, yes, oral evidence. Remember, let me just look at the rule just to answer you. Where the claim relates to money, where the conflicting claims relate to immovable. Okay, let me just see. Okay, so to simultaneously with the delivery by a claimant of particulars of such claimants shall specify an address of service. Okay. So the court can do this. This is what the rule says. The rule 58(6)(c) says that the court can, if a claimant delivers particulars of claim and appears before it, the court, so it is oral because they appear before it, the court may then and there adjudicate upon such claim after hearing such evidence as it deems fit. So the court does hear oral evidence and it can adjudicate immediately, or the court can order that any claimant be made a defendant in any action already commenced in respect of the subject matter in dispute in lieu of or in addition to the applicant. Or the court can order that any issue between the claimants be stated by way of a special case or otherwise and tried, and for that purpose order which claimant, the plaintiff, and which shall be the defendant. If it considers that the matter is not a proper matter for relief by way of interpleader, it may dismiss that application. And it can make an order as to cost. So it is evidence that the court hears, yes. Like this is a specific kind of an application. So there is an affidavit, but the court can hear oral evidence. Okay, just read Rule 48(6). That is what I've read out to you now. Okay. Okay. Yeah. Thanks. I see that. I see the message that some of you couldn't attend match court. That's why you couldn't answer me. Okay, I take notice of that. Right. Another specific, I'm just moving through specific applications. Another specific application in terms of Rule 57 is the application for the appointment of a moderator. Oh, yes, proceed.
Advocate.
Yes, I'm listening.
Yes, Partha here. Yes, I just want to check with you regarding Rule 58, sub Rule 6E, where order as to costs are being made by the court. Who will be liable for those costs, is the applicant, or will the cost be made against the claimants?
The claimant,
in this regard.
Remember one of the things, if you look further up in the rule, you will see that the claimant, sorry, not the claimant, the applicant will say that he claims, where is it? Where the statement relates to a thing. Let me just see. I told you that earlier on. Right. Okay. He claims no interest in the subject matter in dispute other than for charges and costs. 4A. So the applicant will say in the affidavit that he only wants the costs and claim charges. So whoever is the one that is unsuccessful, probably in proving that he is that the applicant is liable towards him. If he's unsuccessful, he will be liable for the costs then, because the applicant says in the affidavit, if you look at the 58.4, he claims no interest in the subject matter in dispute other than for charges and for costs. So he's not going to be liable for costs, but whatever cost he had incurred.
So, well, in simple.
Excuse me?
So, well, if I understand you correctly, I'm saying if I understand you correctly, Counsel, it means the applicant and the claimant who's going to be successful, they will be immune from the costs. But the one who's going to fail to prove his case, the claimant who's going to fail to prove his case is the one who's going to bear the cost.
Yes, I wouldn't use as strong a word as immune, because remember, if you can prove that there was some reckless disregard or some misconduct by either of the parties, you could always ask for costs against them for some other reason. So I wouldn't say immune, but in the case where all is fair, the unsuccessful litigant will have to bear the cost, yes.
All right. Now, thank you, Advocate.
Okay.
But Advocate, why would the applicant in such a case ever be an unsuccessful applicant? Because
the applicant can never be unsuccessful because he's not a party.
Yes, okay, that clarifies it, because the only reason why he's going in for an interpleader is
avoid
because he has some kind of a doubt as to where the funds should lie, and he's admitted his liability anyway.
Yeah, so he wants to avoid cost orders against him, because if he's going to pay the wrong one and the right one takes him to court and makes an order against him, he's going to be liable for cost and to pay another person. Yeah, he wants to avoid that. This is now in that situation. Yes.
Yeah. So just to clarify, I mean, he's not being a party means he can never be unsuccessful in the application.
No, he can't, because there's two people that's claiming money from him and he doesn't know who to pay. So he's asking the court to help him to decide who is the rightful person. And he's willing to pay whoever needs to be paid. That's his whole attitude.
And thanks for the gentleman earlier for asking the question. Thank you.
Okay, sure. Right. Are there any more questions?
Yes, Counsel, thank you. Counsel, it seems that this process is triggered by a person or an applicant who is under liability. So in the example that we have given, and that happen quite often in court, where property is attached and the person who purport to be the rightful owner is a third person who's not under liability. So how does it work? Because it means that he does not meet the requirement of Rule 58, because he will not be under liability, but he would be arguing that, look, the property that is attached, it's mine. How does it happen?
The sheriff in that case, look, he will inform the sheriff who has attached the property. Look, that's my property. And remember, the sheriff, when he attached the property, would have acted on behalf of a judgment creditor, somebody who got a judgment against the judgment debtor. and who says this property must be sold so that my debt can be paid. So the sheriff is the one that's holding that property. So the judgment creditor who's given him the instruction to go and execute, he's claiming that, he's one of the claimants, and the person who's alleging that I'm the owner and it's not the judgment debtor who's the owner, that is the other claimant. So those are the two claimants. So the sheriff would serve an interpleader and we would be the applicant. I don't know if you are satisfied with my answer. You've gone. Hello? Are you there?
Oh, yes, I actually lost, not if it is from my side. Yeah.
Oh, did you hear
but
me?
I follow.
Okay. Are you, did you understand? Are you happy with
Yes,
that answer?
yes, I did. Thank
Okay.
you.
So the sheriff will serve will be the applicant because he has the property now, but he's keeping it on behalf of there's one person that says, sheriff, you are keeping it for me. I'm the creditor. And that must be sold so that I can get my money. And then the owner says, but no, this is mine. It's not the judgment debtors. It's mine. So those are the two claimants and the sheriff will be the applicant. Okay. Right. Are there any further questions? None. Right. We're moving on then to the next application, which is an application for the appointment of curators. Now, this is not the curator for a minor, where the minor don't have a guardian or where the guardian can't act in the interest of the minor. This is not that curator, although the curator ad litem is the same curator, but this specific application is where a person is going to be declared of unsound mind. Now, remember, we did it with locus standi. I said to you that in some cases where a person has been declared of unsound mind, his family can't deal with his business and his property, and then the court must appoint a curator bonis. That is the final relief that you want. You want somebody to be appointed to do the affairs, to handle the affairs of the person who's declared of unsound mind, right? So to come to that, where the court actually appoints the curator bonus, you must walk, you must take this journey, right? You bring the application in two parts, because first you're going to appoint a curator ad litem, right? Now, and Rule 57 deals with this. Now, when you're going to appoint the curator ad litem, this is an ex parte application, by the way, so you would use the short form. Sorry. In the notice of motion, you'll have praise in respect of the appointment of the curator ad litem, and that the court has jurisdiction to hear the matter, right? And then there will be a founding affidavit that is made by the applicant. Now, the applicant in the application for a curator ad litem can be a family member, a caregiver. If the person is in an old age home or in a frail care facility, it can even be the superintendent or the matron, and it can even be the attorney who brings the application, right? To have the person declared of unsound mind. And in this papers, we call the person who is about to be declared of unsound mind, we refer to that person as a patient, because remember, this person is sick, or yeah, they in the papers as the patient. So the curator ad litem must first be appointed, right? So you bring the application in the founding affidavit. The applicant will state his locus standi, why he can bring the application, in what regard he's bringing it. If it's an attorney, will say why he is bringing it. There's no one else, or whatever the reason is. You will state the patient's particulars, who the patient is, names, details, all of that, status, and the relationship between him or her and the patient, and the reasons why the patient needs a curator. The applicant will state that the patient maybe was involved in a motor vehicle accident and he was brain damaged. He suffered brain injuries, or he was diagnosed with dementia or Alzheimer's disease, and he can't handle his or her own affairs, right? Or whatever the reason is that the patient can't handle their own affairs, he will say that. I will also give particulars of suggested curators. Now, curators, because you're going to appoint a curator ad litem and a curator bonis. The curator ad litem at this stage is going to be appointed only, but already at this stage in the founding affidavit, you state who you propose is going to be the curator ad litem, that you have asked this person, you've approached this person, and this person has agreed to be appointed as the curator ad litem. It's usually a legal practitioner that they appoint as curator ad litem, but it doesn't have to be, but usually it is. And also that you've approached a person to be the curator bonis and that this person have agreed to be appointed as the curator bonis. Now, this people who have agreed, then you must attach the documentary evidence that they have agreed. So it would be a consent. Basically, it will have the heading of the court. In the tramlines, it will say consent, and then it will just, I, the undersigned, do hereby, and the name, say if it was me, I, the undersigned, Loreen Abrams, do hereby consent to be appointed as the curator ad litem to the patient if the court should so appoint me. So you attach that also to the founding affidavit. And then, yeah, you will give the particulars of the suggested curator and the statement of the willingness of them to act with the proof that they've signed that consent, and disclose any relationship to the patient or any personal interest that you have to the patient. Disclose all of that. Also, you must attach affidavits of 2 medical practitioners, right? And the rule says, Rule 57 says, one of the medical practitioners must be an alienist. Now, an alienist would be a psychiatrist, or it can be a neurologist or a neurosurgeon. One of them must be somebody who can diagnose person to be of unsound mind. The other medical practitioner can be a general practitioner. Both of them can be psychiatrists. But independently of each other, we need 2 medical practitioners affidavits, and in the affidavits they must state that they are not related to the patient and have no interest in the order sought. Sought is spelled wrong there on the slide. Also that they've recently examined the patient with a view of reporting to the court on the condition of the patient. They must state what observations they have made at the examination regarding the patient's conditions and give their opinion as to the nature, the extent, and the probable duration of the condition of the patient. And why do they say that? And then lastly, they must say whether in their opinion, the patient would be capable of managing his or her own affairs. So you need 2 of those affidavits, right? Then the matter is then set down in court. It's ex parte, so it's in the unopposed motion court. And if the court is so satisfied, the court will appoint the curator ad litem. Now, once the curator ad litem is appointed, he has the following duties. He must interview the patient without delay. As soon as possible, get to the patient, also interview the patient, make all the necessary inquiries about the patient's family members, who are they, what are they doing, how they're involved. And then he must, most important job of the curator ad litem is to prepare and file a report on the matter and to nominate. This is what the most important thing is that you must do, is to nominate for appointment of curator bonis, who is the most suitable to be appointed as the person to be handling the affairs of the patient, right? So he files the report. In the report, he will say what investigations he has undertaken into the condition and the capacity of the patient. What is the patient's physical circumstances? What is the patient's financial means? Anything, yeah. And he must investigate.
Sorry to interrupt.
Yes.
I'm still not clear on the interpleader discussion. I don't understand what necessitates someone to actually interplead. I didn't understand the scenario that you gave. It was rather complex. Can you please repeat that for me?
Who is speaking now?
It's Emily.
Emily. Okay,
Yes.
so everything I just said now about curators, you didn't follow because you were thinking about the interpleader.
Well,
Okay.
I didn't understand the part that you
interpleader, okay.
explained on the interpleader, but I do understand on the curator at, yes.
So you want me
Yes.
to go back to interpleader? Okay, if the rest of
Please.
you don't mind, let me just go back and explain to Emily. Emily, when you have when you're a person and you expect that two people can sue you, but you know you owe one of them money, but you possibly may even owe the other one also, and you yourself as a layperson, you're not sure who's the rightful person whom you are liable to for this money, right? Or not just money, whatever, property, whatever. They can both claim from you. You know you owe it, but you don't know who. You then serve an interpleader so that the court can decide who is the rightful person that you must owe it to.
Okay,
In short,
I
do you get it now?
get it. Thank you.
Okay, fine. Right. Let me just get back to. Yes, you're still not happy, Emily? You can ask.
I'm satisfied. I'm satisfied. Thank you.
Okay, yeah, just read the example. It relates to a farm where the estate agent who actually sold the farm, who was first employed by one employer, and then when he sold the farm by another employer, and both of his bosses, both of the agencies wanted to claim the commission. And the farmer knows he owes one of them, but he didn't know who he owes. And then the procedure is set out how you go about so that the court can decide who is the rightful owner. Okay.
Okay. Okay. Thank you.
Advocate, before you go on with the discussion of curators, if you can just clarify again the difference between curator ad litem and curator bonus, because I understanding it correctly, the curator ad litem is one that can represent the particular party with who is challenged in proceedings, all right? And curator bonus is the one that actually runs his affairs. Is that the proper distinction?
That is correct. That is correct.
All right.
So a curator ad litem is a guardian for the suit. He usually stands in for legal proceedings, but in this case, when he's appointed in this, in terms of an application to have a person to be declared of unsound mind, he also has certain duties in terms of that rules, and one of to advise the court and to recommend who is the most suitable person to be appointed the curator bonus.
Okay. So
yeah, specific duties in this. Like for the minor, you would stand in place of the person in legal, and in here also you would stand in place in legal proceedings. But his most important job here is to see and advise the court who is most suitable, because he will do that investigations.
So is it then proper to say that a curator bonus cannot be appointed before curator ad litem?
Yes, that is correct. That is why I said you bring the application in two parts. First, you have to appoint the curator ad litem. And then he does his investigation, he files a report, and then only once everybody is satisfied will the curator bonus be appointed.
Thank you very much. Yeah, thank you.
Okay, right. So the curator ad litem's duties is then to interview, I've already said that, to prepare and file a report on the matter, and also then to nominate, the person nominated to investigate whether that person is then suitable to be appointed as the curator bonus. Now remember, the curator bonus is going to handle the affairs of the patient. He's going to take control of the estate of the patient and deal with the monies and deal with the business and that. So the curator ad litem must see to it that this person is suitable. Apart from that, this report that the curator ad litem compiles, he files it with the court, and he must file a copy of it with the master of the High Court. Now, the master of the High Court must then file a report also to court, once he's received the curator ad litem's report, to say whether the master agrees with the recommendation of the curator ad litem, that this person who he says recommends to be appointed as the curator bonus appointed. Now, the master, in terms of the Administration of Estates Act, requires that the person who is appointed as a curator bonus must give security to the value of the estate which it's going to handle. So if the estate is 5 million, the curator bonus must give security. So the master will require security. So the curator bonus, if he recommends somebody, he will then ask the master to waive the security and see if the master wants to waive that. Or they can recommend that this person is appointed and this person has sufficient security, which the person will then give to the master. Right. Now, the master waives the requirement of security if the person to be appointed as the curator bonus is an attorney with a valid fidelity fund certificate. Then the master will waive the requirement of the curator bonus to give that security. Otherwise, the master would require security because, remember, the money and the estate must last for as long as the patient is alive, and the curator bonus should then, if he should do something with the money, the master has security that that money is going to be there, because the master then must look after the patient's money. The curator bonus must also report to the master what he has done. I think it's quarterly, what he has done with the estate, what he's invested, how he has dealt with the money, how much money there is. So the master has an oversight over the functions of the curator bonus. Obviously, the curator bonus get paid also from the estate, a certain percentage, but he has to report to the master, and the master have oversight. And as soon as the curator bonus, if it's an attorney who didn't give security, doesn't have a fidelity fund certificate anymore, the curator bonus will be replaced by the master. The master will see to it that somebody who does have a valid fidelity fund certificate be appointed. Right. So once the master and the court and everybody agrees who is now this person is a suitable person to be appointed, the curator bonus is appointed. So you go back to court on the same papers, with including now the curator ad litem's report and including the master's report, where the master says whether he's waiving the requirement or whether he's going to accept security or what, and that the person is suitable. Okay, so the curator ad litem, when it does its investigation into the suitability of the person, if the person is not an attorney, you will obviously have to also be sure that the person who is going to recommend has that security, and he will state that in his report, that that person can provide security. And this usually in road accident fund matters, where the road accident fund is going to pay out huge amounts to victims that has been brain injured. The family usually wants the money, and they don't understand, because the road accident fund would insist that the curator bonus be appointed, because if the money is going to the family, the money might be used up before the patient dies, and then the patient doesn't have anything. So they insist on that. And then usually you would recommend an attorney or something, or somebody that can give security to handle the affairs. And that person usually handles it in consultation with the caregiver of the patient. So whatever they need for day-to-day maintenance, and whatever extra monies they need, if they want to renovate the house, if they want a vehicle to be customized, or whatever, depending on the size of the estate, it will be in consultation with the curator bonus. And like I said, the master have oversight. And yeah. Are there any questions on curators? I don't know if you saw that movie on Netflix, I Care. Some of you must have seen it. It's also about when a curator is appointed for patients. That movie actually brings home the fact that when a curator is appointed for you, you are really not in control of any of your affairs. They take control of all your money day to day. Even if you get better and you work, you are able to work, the fact that you were declared to be of unsound mind and incapable of handling your own affairs, that has an impact on the rest of your life, because all monies that you earn will go to the curator Bonis, and he will deal with it. Yeah. You can reverse it, but then you're going to need those experts who said that maybe it's irreversible Alzheimer's disease. It's going to just get worse. It's not going to get better. You will have to bring an application then to say that, look, it's changed now. The curator, you don't need a curator Bonis anymore. You want to take care of your own, depending. If your injury, maybe it was wrongly diagnosed and it wasn't so severe that you needed somebody to take care. There is a vehicle in rule 57 that you can change it also. Right. Okay, any questions? It's also our break time now, so let's take the break and then come back. Thank you. I am back. So I will proceed from where we ended. Are there any questions at this stage on curators? Because that is where I end curators. Are there any questions? Yes, you may ask. Whoever sounds I'm hearing, you may ask.
Hi, how are you?
I'm well, thank you. Proceed with your question.
Good. Okay, I just want to know that is an attorney allowed to put money to a curator? Maybe let's say okay, let me put it like this. The question, let's say the tenant was involved in a car accident, and the client received money from the road accident fund. Then the attorney says, no, this client never have so much money in her life or in his life, so the money must be put onto a curator because the client won't be able to manage the money.
Is there application for a curator to be appointed? Does the attorney suggest that?
No, the attorney just said he has put the money to a curator. Then whenever the client wants something, they will come to the attorney and request. But there was no application was made. There's nothing has been made in terms of application of the curator.
Well, if the attorney tells you that yes, the money is with the curator, then you must ask where's the court order that the curator was appointed to deal with the affairs of the patient as such. Has the person been declared to be incapable? Because only if the person is declared to be incapable.
Okay, the person was not declared. The attorney just assumed that since the person has never received such money, I work for the road accident fund, so some of my clients who came with such a.
So the attorney didn't want to give the money to the client and told the client, I've given it to a curator. No, the attorney can't appoint a curator.
There's no court order. Yes, the attorney didn't appoint a curator when I see. He just put the money away and say, whenever the client needs money, you come to him and request, and he'll give you that money if maybe you want to build a house or buy a car, like what you said. The curator does.
Yeah, but the attorney can't himself decide. No. I think you need to investigate. Whoever the client is, need to investigate the attorney to find out whether, in fact, what is the attorney talking about? Because sometimes the court also on the attorney's request have a trust created for the client, for the plaintiff, if it's a huge amount of money and the attorney is concerned, that then they have a trust created with trustees appointed and that. So if it's not that and the attorney says a curator is dealing with the money, by all means, the client can go further and find out where their money is, because the attorney can't just decide that a person can't deal with a huge amount of money. I mean, there's many reported court cases of attorneys who had collected large amounts of money from the road accident fund and gave the clients some of that money and kept the others behind, because for that reasoning, the clients doesn't even know how to use all that money or something like that. I mean, we have reported cases on that where attorneys have been struck from the road.
In terms of this kind of, since as road accident fund cannot assist the person, the client, because the money have already been paid to his attorney. So where must the client go now to
the legal practice council,
attorney, or he must go to the law society?
He must go to the legal practice council and report the attorney so that they can ask the attorney what's going on here. And obviously, you as the road accident fund have given can give the plaintiff proof of what amount was paid out and when it was paid out, when the matter was settled or dealt with. You could do that, because I know Yeah, so you can go and say and tell the Law Society, look, this is what the attorney says. There was no court application, and then they will do an investigation to see what's going on and report back to the client and see that things are, yeah.
Okay, thank you.
Are there any other questions?
Yes, Advocate, can I go ahead?
Must I go ahead?
Can I go ahead,
Yes,
Advocate?
you can. Yes, you can.
I heard you saying there are attorneys who are not members of the Fidelity Fund, and they will be required to file securities. My impression, I've been thinking that all the attorneys must be the members. Am I wrong?
No, I didn't say that there are attorneys who are not members. Maybe you misheard. I said if the attorney should not look at some points and times, then it's money that you have to pay to the Legal Practice Council, and if you're late or if you don't pay it in time, you might lose your Fidelity Fund certificate for a period of time.
Oh yes.
Then then you can also not be for that time when you don't have a valid Fidelity Fund certificate. If your books is not right or you're busy with the laws with the Legal Practice Council, then you cannot be the curator bonus.
So Advocate, you are saying all attorneys, including those who do not hold trust accounts, must have that Fidelity membership?
No. It is the company that has the Fidelity Fund certificate, isn't it? The one who accept who's registered with the Legal Practice Council. And all the attorneys falls under his Fidelity Fund certificate. Doesn't it work like that?
All right. Okay. Maybe I've missed a point, but I'll thank you for having.
Now you look. Yes, you must be covered by the Fidelity Fund as an attorney. So if you are employed by a company of attorneys as an attorney, then you're covered by that company. That's my understanding, but I may be incorrect. I'm not a practicing attorney. So if somebody knows more about that, they can. But my understanding is if you are employed by a company, the company has a trust account, not each individual attorney for that company, because you work in the name of that company, and that company has a Fidelity Fund certificate, and you fall under, you are covered by that Fidelity Fund certificate. That is my understanding. Okay.
All right. Thank you, Advocate. Thanks.
Okay, sure.
Yes. Okay, so in our discussion on appointment of curators, we covered situations related to people who are incapable of managing their affairs because they are of unsound mind. Now, do prodigals fall under the same rule as well? People who are not of unsound mind but incapable of managing their own affairs. So, does a curator ad litem or a curator bonus need to be appointed for them as well? Because that's a totally different category to somebody who is mentally challenged now.
No, it's totally different, because remember, there's years now medical experts that must examine and diagnose and say no. It's totally different. But and I think it would also be temporary until the person can show again that they can handle their own affairs. But I think that is because prodigal is when you're a spendthrift, or when your family is concerned that you're wasting your money, and they bring an application that that somebody is appointed. But it's not the same. No, it's not the same. It's different.
But who is the one that's appointed? Isn't he also referred to as a curator ad litem or a curator bonus?
It would be a curator bonus then that would be appointed.
Thank you. Thank you.
Okay. Anything else?
Yes, Advocate.
Yes, I can hear.
Thank you. Yes, I'd like to ask about this curator bonus.
Yes.
Because you said you must manage the affairs of the patient up until possibly death, unless, of course, the patient have shown some full recovery, upon which there has to be an application into that effect.
Yes.
Now, I want to check now if this patient has got kids, and then he's the sole parent of them, and then he passes on, he or she passes on. Now, what will happen to those kids? Do they have to have a separate application since, for example, they are still underage, or what's going to happen to them?
Just say that who's underage? The patient.
The patient has got kids.
Oh, okay. Then it will go to the guardian. And remember, then it falls then into the estate of the deceased, whether the deceased was not incapable of handling. It falls in the estate of the deceased, and the curator is then released because the patient whom he was representing is no longer there. And it falls in the estate, and then it is dealt with in terms of whatever, if there was a will or interstate succession.
Oh, okay. All right. Thank you.
Okay. Anyone else? Can I move away from curator?
Yes.
Okay, I will. The next, yes. Oh, there's another question. Yes. You may proceed. Okay, I'm going to go on. Right, the next application that I'm going to deal with is an Anton Piller application. Now, an Anton Piller application, I don't want to tell a lie. What case is that? No, Anton Piller is part of the case name, and it is part of the Anton Piller. This is an application to preserve evidence to enable the applicant to obtain substantive relief later, and it is made ex parte. Okay, they don't have the name in your book as well. Let me just quickly Google it. Okay, let me just tell you when you would use the Anton Piller application. If you are going to institute proceedings against someone, but you know that this person, if the sheriff is coming to serve him with this papers, with this summons, he's going to destroy evidence or hide evidence that you will need in order to prove your case that he has. So to avoid that from happening, you go to court and you bring an Anton Piller application, and that is now an application that is in camera. That means it's behind closed doors in secret, so that nobody can witness that. And you must tell the court in your papers that you have a cause of action against the respondent, and that the respondent has in its possession documents or things which constitute vital evidence in substantiation of your cause of action, and that you have a real and well-founded apprehension that the evidence may be hidden or destroyed. You must be specific about the actual evidence that is destroyed. This is just part of the Cape Town, Western Cape Practice Division practice note. I'm going to tell you about that. You must specify what the evidence is that you want to be preserved. So it is a preservation order. I don't know, you must have seen preservation orders in terms of the POCA, the Prevention of Organized Crime Act. That is where the police goes and they preserve property that they allege has been obtained by ill-gotten gains. And if there's a case pending against somebody, and it's usually these high-flyer gangsters and high-flyer criminals who they get this orders against, the preservation order. So an Anton Piller order is similar to that, where you want to preserve evidence. Okay. You then what happens, it's brought in camera. That means now in the judge's chambers. Once the judge is convinced that you know the evidence, what the evidence is, and that he's convinced of your version that there is a well-founded apprehension that it might be destroyed or hidden, the sheriff will then be appointed together with another attorney who is not the attorney of the applicant. That attorney they refer to as the supervising attorney. Now, the supervising attorney and the sheriff will then go to the property where the evidence is. They will inform whoever is in charge of that property. Look here, we are here with this court order. We've obtained it in camera. You can call the respondent. That is not if it's not the respondent himself. And you can also have your attorney here. The sheriff and the supervising attorney will then give a reasonable time for which those people can come, must arrive, but they will go to where the evidence is and they will secure the evidence while they are waiting. And then when the time has lapsed and the people comes, or if the time, reasonable time has lapsed, they will take the evidence and the sheriff will keep it in his custody, in his possession until the trial is held, unless the respondent comes to court and have it overturned by saying that this is nonsense. There is no case or there is no well-grounded apprehension that he was going to do anything with that evidence and it should be returned to him. And the evidence can be anything. It can be even be on computers and stuff, and then that is taken away. Right. So that is the Anton Piller procedure. It is an extreme procedure, but to retain evidence and to prove a case, it is very essential that we have this vehicle there. Yeah. Are there any questions on Anton Piller? Nothing. If your hand is up, you can ask. I can't see your hand. Right. So let me just give you this background of this, how people in the past, when you didn't have to specify that what the evidence is, what people did is they went on fishing expeditions. It was easy to say you have a case against someone who's maybe your rival in business. They're manufacturing things, and then you say you're going to institute and you need to go and get that evidence and then you get all these secrets. So, yeah, there was an attempt to eradicate the Anton Piller procedure from the South African legal system during the late 1970s and early 80s. It became widespread and the subject of serious abuse. Right? So orders were frequently brought to compel respondents to submit to the raiding of the business and or the premises. And the strong judicial reaction was against these abuses, and they said, look, you must know what evidence it is that you want to have attached. You can't just go take everything in the hope that some of it might help you in your case. Okay. The case name is Anton Piller KG versus Manufacturing Processes Limited and others. It's 1976. 1. All England Report 779 in brackets CA. It was devised in England to prevent a situation where people destroy evidence. So you can go to your opponent and look at his property and take the evidence. Okay, this is a question where you have to draft an index. So it basically involves let me go through it quickly. Mr. Cloete comes to you, Mrs. Cloete comes to see you and informs you that her husband, James Cloete, who is 56 years old, has been diagnosed with Alzheimer's disease and cannot handle his own affairs. You advise her that a curator has to be appointed by the High Court. She instructs you to go ahead. You successfully apply to court for the appointment of the curator ad litem. The matter is now set down for the appointment of a curator bonis. So now you're at the second step. Then the question was prepare an index for the court file. Now, this example was to see if you know how to do an index. As an attorney, that is one of your duties, remember. So you will have the heading, and it's an ex parte application. So this is what the heading would look like. In the tram lines, you would have index. Sorry. In the tram lines, you would have index, and then you would have the item number. And there is an example of an index. I usually would refer people to an example of an index. That index is an index in an appeal matter, but you can follow that format and then do the index of this application. And this question also tests your knowledge on whether you know what must all be in the court file when you are bringing an application for the appointment of a curator. So basically, let me just quickly run through it with you. What must be in the court file? It's the notice of motion. That would be the first one. Founding affidavit. Second one, consent form from the curator ad litem. Consent form from the curator bonis. Medical practitioner's affidavit 1 and medical practitioner's affidavit 2. And then you will have the court order appointing the curator ad litem. And then after that, you will have the report by the curator ad litem, and then the report by the master, and then the notice of set down for the application to have the curator bonis appointed. So that would all have to be there. There's an example of an index for the format on page 272 of your notes as to how to answer that. Right. Yeah. These all got to do with the next special application or specific application is a PI application. Do you all know what a PI application is? It's an application for an eviction order against an unlawful occupier of property. Right. So you will note that each, I have some notes on PI applications which you can read through. I will just tell you what PI applications are. Each division has their own rules with PI applications with regards to PI applications, right? As to when you should bring the section 4.1 and section 4.2 notice. So basically, PI stands for the prevention of illegal eviction of unlawful, the prevention of illegal eviction of unlawful occupiers Act. Right, that is there. Now, in terms of that Act, section 4, you can't evict a person who from his residence. When a person is residing in a property, you can't just evict him without a court order. And the court order that you must obtain is in terms of this Act, the PI Act. Now, you would serve the papers. It's a notice of motion and an affidavit. That is a section 4.1 notice. You serve it on the respondents and then tell them that you're evicting them. But before that, you must make sure that they are unlawful occupiers. So if you didn't cancel a lease agreement, you must do it in writing, cancel, tell them that they must move out, give them a time. And if they don't move out, then they are illegal occupants. So they must be illegal occupants and not in terms of a valid lease agreement. You must first cancel the lease agreement. Also, but if they are just there because they just moved in and they don't want to move out, or the contract that you had said they must pay rent and they haven't paid rent for a while, and immediately then they are illegal occupants, then you can bring the application, right? So you bring the first part, it's served on them. Then you must serve another notice. This is the difference between a normal application and this application. They call it a section 4.2 notice. That is the ex parte notice. So you go to court, you bring this ex parte application that you have to serve the application again on the respondents. And here, this is where you have the court date. So it must be served 14 days, at least 14 days before the court date, and that is calendar days because it's in terms of a statute. So 14 days before the court date, and you must advise them that they can go to legal aid. And there are certain requirements that you must take into consideration if you're going to evict persons. So you must demonstrate to the court that you've taken into consideration that who's living there and whether they could afford alternative accommodation, etc. Also, you must serve a copy of these papers on the municipality who is responsible to provide housing for that area where the illegal occupant resides. And then it is dealt with as a normal application. Once they've got the section 4.2 notice and you're in court, then the court will then determine when they should move out. Okay, so yeah. To resist the PI application, to oppose it, you can only buy more time. But really, at the end of the day, the landlord also has rights, and that is the right to his property. What the court do, the court looks at the circumstances of the unlawful occupier, and see how it can assist them to find alternative accommodation. But the court can't say that they must stay there forever and ever in the property. So resisting it or opposing it, they can buy more time, but eventually they will have to move out. I don't know, that's like saying a lot in a very short time. If there's any questions on PI applications, it's pretty straightforward. It's just that there's a section 4.2 notice as well. Yes?
Can I ask? It's me, Emily, again. Is PI an acronym or something?
Yeah, it's an acronym. It's the Prevention of Illegal Eviction and of Unlawful Occupiers Act.
Oh, good.
I think it's 119 of 1998. I don't see it in the notes. I was checking in the notes whether they actually say what the act is, but it is a prevention of illegal eviction.
It is on page 196.
Yeah, no, PI, it says PI on page 196, doesn't it? Or does it say the act? Where does it say it?
The second paragraph under
8.6. Okay.
864.
Okay, yeah, there it is. So it's that, yeah, that it's an acronym we say PI Act because it's a long title, but yeah. Emily, do you have any more questions? Oh, okay.
No, thank you. That will be all.
Okay, no, fine. Then that is also a specific application. Remember in your exam, the PBST exam that you're going to be writing, they're going to give you facts before the time to read through. And then at the exam, they're going to say, look at scenario so-and-so, and then they're going to ask you questions. You are the attorney of these people. This is what's happening to them. How would you advise them? Draft the papers, do this, and they will give you facts. So you need to know what to draft and what needs to be there. Yeah. Right. So you might get to have to do a PI application. Okay, so now we come to review applications. Review applications and a review of proceedings must always be brought by an application, right? We have the reviews in terms of the uniform rules, that is Rule 53. The grounds for review is set out in Section 21 of Act 10 of 1993, and it is the following: absence of jurisdiction on the part of the court, that the presiding officer had interest in the cause, bias or malice or corruption on the part of the presiding officer, that there was a gross irregularity in the proceedings, that he gave an incorrect judgment. Sorry, that he not an incorrect judgment. That is exactly what it is not. An irregularity refers to the method of conducting the trial. So it is not like an appeal where you look at the record and say this was incorrect. It is the method that was used in the proceedings, and it does not necessarily have to appear from the record. Sometimes it is outside of the record, and in a review proceedings, you can go outside of the record and say that the presiding officer was biased, had malice, he was prejudiced against my client, and therefore we're taking his decision on review. Also, the admission of inadmissible or incompetent evidence, or the rejection of admissible or competent evidence. Those are also grounds in terms of Section 21 for review. Right? So in terms of Rule 53, there's no time limit in which you have to bring the review application. You must just bring it within a reasonable time. In one case, 7 years was found by the court to be unreasonably long. Depending on the circumstances and what you explain to the court will decide what is reasonable. Right? The difference between an application for review and a normal application is that in the notice of motion for the review, then the notice of motion is directed to the decision maker. Right? Now, in the High Court, you review courts below it, inferior courts. So magistrates' courts' decisions can be taken on a review, as well as quasi-judicial bodies' decision can also be taken on a review. Right. Now, the notice of motion is directed to the decision maker. Can be the chairperson of the arbitration, of the hearing, or the magistrate. It is directed to him, and he is called upon to make available the record of the proceedings. Right. So it is directed to the decision maker, in which the decision maker is called upon to furnish the record of the proceedings and also reason for his decision. And you must also set out the grounds for the application for review. Now, at this stage, it is also filed on the respondent, but the respondent on this stage doesn't have to do anything until the record is furnished. And there's also no time limit in which the record must be furnished, but obviously as soon as possible. So once the record is made available, the applicant must then make copies of the record and send it to the respondent. Right? So the registrar will let the applicant know the record is available. The decision maker has made the record available. Then the record is served on the respondent. Now the applicant has another chance. He can now amend his grounds for review, right? Sorry, he can amend his grounds once he's received the record within 10 days after he's received the record. He can say, I'm abandoning this ground because now that he's read the record, he sees maybe he was wrong in the way he understood what happened there. Or he can add more, or he can vary. He can change his grounds for review once he's received the record. And then if the respondent wishes to oppose, within 15 days, he must then deliver his notice of intention to oppose. And then 10 days after that, his answering affidavit. And then the applicant files a replying affidavit, and the matter is then dealt with as normal applications are being dealt with. So the only difference is here is that the notice of motion is first directed to the decision maker to furnish the record of the proceedings and the reasons. And then only, and then the applicant gets a chance to amend his grounds for review. And after that only must the respondent then file his notice of intention to oppose and an answering affidavit, and then it is set down in court. Right. Now there's also yeah, that's the normal, that's this Rule 53 application in tabular form. Now I don't have a note, a slide of this, but we all know that in terms of the, what is it now? Promotion of Administrative Justice Act. There's also that review procedure, which is different to this procedure. Yes, it is. You bring the application for review. There is a time limit in which you must bring. It's 180 days that you have if a constitutional right has been affected and you want to take the administrative action that is affecting your right. You want to take that on review. You bring it in terms of PAJA, the Promotion of Administrative Justice Act. And then you must state then the grounds on which you are bringing the application. And yeah, you have 180 days, is it? 6 months. But you don't have to wait until the last minute. You must bring it as soon as possible because the court can, even if you are waiting, even if you are within the 180 days in bringing that application, the court might still say there was an unreasonable delay. So you must bring it as soon as possible. You have, in terms of law, 180 days. And if you are later than that, then you must bring an application for condemnation as to why you are late and explain to the court why you should be allowed to still bring your application in terms of PAJA. Right. Do you have any questions? I'm going very quickly through these things because it's applications. You have the founding affidavit, you have the answering affidavit, and you're going to argue based on the facts, and you're going to see what is common and what is in dispute. It's the same as the normal applications. It's just that the applications are slightly different. I don't know if you all have read through your notes. Yeah. Okay. No questions.
I have a question.
Ask.
Yes, just on the grounds. All of them I do get, but the one I'm starting with.
You're very soft, sir. I can't hear you. Just can you speak louder?
Yeah, the interest in the cause. What does that mean?
He has a personal interest in this case.
Okay.
Yeah. Usually what happens in courts also, especially in criminal matters, in the high courts, you will see that when those issues are present, according to one of the accused, maybe in the criminal matter, the counsel may get instructions to ask the presiding officer, the judge, to recuse himself, him or herself, because he has an apparent interest or is prejudiced or is biased. Then you can bring an application to have them recused, or for them to recuse themselves. And if they refuse to recuse themselves, you can later on maybe use that as a ground for appeal, one of the grounds for appeal. But yes, if you have a specific interest in the matter. And the reason why I was now thinking of that in the criminal context, I don't know if you all followed that case. I think it's, what is it? Some surname with the O. It was a pastor in the Eastern Cape who was accused of having sexual relations with some of the churchgoers. And there was this one, it was online. We could all watch it. Omotoso, yes. Where they asked for the recusal of the judge. I don't know if you remember. There was this application to have, and he didn't want to recuse himself. But then later on, he recused himself, not for the reasons that was put forward as to why he should, but he said for the reason that his wife owned a guest house where one of the witnesses was staying, and that looks like he has an interest in the matter or something, and he recused himself for this reason. I don't know what happened to that case, but I was just thinking about that when I said what I was saying earlier on. Yeah.
It was Judge Mandela.
Oh, you know the judge.
Yeah. The case is still going on.
Oh, is it still on? But you remember it was televised for some time, and people were watching it. Yeah. Yes. So there was this and he did recuse himself, for that reason, and not for the reasons that they said that he was biased and prejudiced against them. He gave the other reason that his wife owns a guest house, and I think the witnesses stayed there or something. And it didn't look Right. Right. The difference between appeals and reviews. This is exactly in your notes, I think. Appeals must be noted within a particular period in accordance with the Act and the rules, whereas reviews must be brought within a reasonable time. That's one of the differences. In the case of an appeal, the appellant is bound by the record, and in the case of a review, the applicant is not bound by the record. Often an applicant's objection concerns an action or a remiss on the side of the decision maker, which does not appear from the record. I have said that to you already. And on an appeal, it is contended that the presiding officer came to a wrong conclusion on the facts or the law. In the case of the review of the lower court, the grounds on which the review may be brought are limited. There are many other grounds on which a review in respect of decision or proceedings can be brought. Right, those are the basic differences between appeals and reviews. Now, having said that, looking at the second one, where I say in the case of an appeal, the appellant is bound by the record. So if you are going to appeal a decision, right, you are bound by the record. But there are times when you are allowed or when you can apply to bring an application to lead new evidence that has to be considered at the appeal stage. So although the rules, it says that you are bound by the record in your appeal and you can't go outside of the record like you could with review, if there's new evidence that is forthcoming after the judgment, you can bring an application to lead that new evidence so that it can be considered. And in that application, you have to convince the court that the evidence was not available for you to present at the time of the trial, and that if the court considers that evidence which is now available and which you now know of, then it would make a difference to the outcome of the case. And if you convince the court of those two facts, then the court may allow you to lead new evidence and to bring new evidence in at the appeal stage. Okay. Right? It must not be a tactical or strategic decision that you've made to not lead evidence. You had the evidence, it was available, and you just decided no, and then it didn't work. Case was against you, and now you want to come and include that evidence. No, it must be evidence that was not available, and you must demonstrate to the court why it was not available and how it only came to light after judgment. Okay. Right, so the appeal procedure, is there a question?
Excuse me, Advocate.
Yes, you can ask.
In terms of new evidence coming forward, is that then heard in the appeal court, or is that sent back to the
It can be sent back to the
court for hearing?
It is remitted to the court for hearing. But you can after judgment at the appeal, you can say you have new evidence, and then if the court agrees that the new evidence can be led, it will remit the matter back to the court to include that then. Yes.
Thank you.
Because remember, at the appeal court, you don't do oral evidence and evidence. You would so there won't be cross-examination, and that you won't have that available. So it must go back to the trial court then for it to consider the new evidence.
Thank you.
Okay. Right. So if you are going to appeal against a decision of a judge, we're doing high court practice. So if the judge hands down a decision, you can immediately after he hands down his judgment, you can get up if you have instructions. You can say that you are applying for leave to appeal. So you can do it orally immediately after judgment, indicating the grounds for appeal. Then you tell the judge, you were wrong in X, Y, and Z. You were wrong applied the law wrong, you included wrong facts, or whatever your grounds may be. You can tell him, I don't agree, and that's why I bring an application for leave to appeal. Or you can do it in writing. Now, a lot of times you just do it in writing because you must first take instructions, you must first consider the judgment. And if the court just hands down a judgment and it doesn't give you reasons, you must apply for the which has to be given to you 10 days, within 10 days after applying for the reasons. And the application must then be made 15 days after the date of the order or the date on which reasons were given to you. Then you do it in writing, and then you'd file a application for leave to appeal. Right? Now, then the court will then, and if you file it with the judge who handed down the judgment, the same judge, and he will then, and on your opponent, who now becomes the respondent, and you the applicant, because you're applying for leave to appeal. It's just the notice, and you don't have to have an affidavit. You will just argue why you say that. The court will grant a leave to appeal if the court is convinced that another court, when considering the same evidence and applying the law to that evidence, may come to a different decision. So if there's a possibility that another court may come to a different decision, the court will grant you leave to appeal. If the court is of the opinion that no, another court will not find differently, the court can dismiss your application for leave to appeal. It is usually argued in front of that judge, and that judge will tell you when you can come and argue, your application for leave to appeal. Yeah, the respondent will also be there and will say why you should not be granted leave to appeal if he's going to oppose it. If the court gives you leave to appeal, then you will file your notice of appeal, and you will set out the grounds in the notice of appeal, right? If the court refuses to give you leave to appeal, then you have to bring an application to the Supreme Court of Appeal. Now this, they say you petition the Supreme Court of Appeal because previously you had to write a petition. It was a specific kind of document. Now it is an application, so it's a notice of motion and an affidavit, which you are going to now send to the Supreme Court of Appeal. You're not going to argue this application for leave to appeal at the Supreme Court of Appeal. The court is going to decide it on the papers. Okay, so you bring an application to the SCA. It will then be decided by judges in chambers whether you should have been granted leave to appeal. You must provide all the information that will be necessary to enable the court to decide whether they should give you leave to appeal. The application must be accompanied by a copy of the judgment of the court ACWO, that is the court below who made the decision, ACWO, and the judgment refusing leave to appeal, if that is the case, which is the reason why I bring it. And then your opponent can file an answering affidavit, and then the appeal judges may grant or refuse the application or refer the matter to court for reconsideration. Okay, and then when you are given leave to appeal, then you must file your notice, and then in terms of if it is in the Supreme Court of Appeal, you must follow that Supreme Court of Appeal rules as to when you should file heads of argument and how the record should be filed and all of that. If leave to the appeal to the full court is granted, that is now the same court where the matter was heard, then the appellant must deliver the notice of appeal to all the parties within 20 days after leave has been granted. And remember, this is all in terms of the uniform rules, and it is 20 days calculated first day out, last day in, not weekends and public holidays. So it's court days, 20 court days. If leave to the appeal to the SCA, the appellant must lodge the notice of appeal with the registrars of both the court and the Supreme Court of Appeal and the court where the judgment was handed down within 20 days. And the notice of appeal must state whether the whole or part of the judgment appealed against. And if only part of the judgment is appealed again, which part, and specify the findings of facts or rulings of law that he is appealing against, and specify the grounds upon which the appeal is founded. Right. Do you have any questions? No questions. Right, so then I come to this part where attachment and sale of corporeals in the High Court by the execution of judgments. Now, there are two types of execution of judgments in the High Court, right? There's the attachment of movables. So once you have a judgment, right, the judgment must now be satisfied. And if the judgment debtor does not satisfy, then you must issue a writ of execution. Now, the first thing that that you must do is you must check whether not you, but the sheriff on your behalf, they're going to check whether there's enough movable assets to sell, right? So what happens is you issue the writ of execution. It is High Court Form 18. It's given to the sheriff. The sheriff then proceeds to the judgment debtor, to the house where the judgment debtor is or where his assets is. And he says, we've got this judgment. Can you satisfy this judgment? If the judgment debtor satisfy the judgment debt, then that is the end of the proceedings, right? If not, if he says, I don't have the money, the sheriff must then attach the movable property that is sufficient to satisfy the writ. Now, those of you who have seen the sheriff attach judgment property, you will see that the sheriff writes the items, and then he will give a value to the items as to for what money it will fetch. And it's usually ridiculously low as to the value of the stuff, but that is what the sheriff does. Then the property is then taken into custody and it is sold at a public auction. Now, if the money that is raised, that is sold at the public auction, is not enough to cover the judgment debt, then you, as the judgment debtor, still owes the balance. Okay, it doesn't mean that only what you can get that is now, and the debt is now satisfied. No, they will still, if there's still a balance, you still owe the balance. And remember, a judgment debt, my screen went blank. Can you hear me? Can you hear
Yes,
me? Oh,
yes,
sorry, my screen just went blank. The judgment debt, thank you. The judgment debt is valid.
Yes, we can still see the screen.
Oh, you can. Okay. The judgment debt is valid for a period of 30 years. So they can still enforce it to get the rest of the money. Right, so I can't see.
Can I ask a question, ma'am?
Yes, you can.
What if the goods are sold for far more than the debt is there?
You get, yeah.
Okay.
You get the
The
change.
excess is, okay, thank you.
Yes, you will get the changes. I don't know if that ever happens, but yeah, because the sheriff will then, the sheriff, when he writes up, he will write up just enough to cover the debt. But if they fetch more money, then you get the change. But you know how these things work in practice. Right.
Yeah,
with immovable property, it is different. Once the sheriff sends a registered letter to the judgment debtor, and also who occupies the person who occupies the immovable property might not be the judgment debtor, then your property is deemed to have been attached. Now, then there's a lot of duties that the sheriff has and that the attorney has, the attorney for the judgment creditor has, things that they must do. It must, they must file notices that must be made available on the, is it the board of the court? And they must also, yeah. before they can actually sell the property at execution. But before I come there, I need to tell you this because I don't have a slide on this, but this is very important. Rule 46A came into operation, 46 capital A came into operation. I think it is 2017, 22 December 2017, the end of 2017. Now, this makes specific provision if you are going to declare immovable property to be sold, to be executable. There's a certain procedure that you have to follow. You can't just like in the past ask that the immovable property be declared executable and then they can sell the property. No, there's a certain, you must bring an application to have the property sold at the public auction to be able to execute the property. This is only in the instance where the property that you want to be sold is used for residential purposes. So if it is the primary residence of the judgment debtor, you can't just go and sell the property to get your money. You must bring an application to sell it. And then you must, in your application, you must demonstrate to the court that this is the last resort, that you've considered all other options and that there's no other ways for you to be able to get this judgment debt satisfied. And the court must be convinced that you have done all of that before the court is going to declare that you can sell a residence to get the cost. And the court also insists on a reserve price to be agreed on. And the court will make a reasonable reserve price so that the property is not sold for ridiculous amounts of money. You might have heard of cases in the past where houses were sold for ridiculous amounts of money for small debts, and then people were homeless as a result of that. So to avoid all of that, they have this in place. And yeah, the respondent can come to court also and oppose this application to have the property sold, the immovable property sold at an auction. Okay. So yeah, the application must include to sell the property, the value of the property, the market value of the property, what is the municipal value of the property, what amounts is owed to the bank on a mortgage, what amount is owed for rates, all of that. So the judgment creditor must do an investigation and have all of that information and set it before the court. Okay, and then you can oppose it as the judgment debtor, and the court will then consider the application. Yeah, that's that. I don't know. Do you have any questions on this? Look, I went quickly over tonight's stuff. There's a black thing that I can't get rid of here on my screen. Sorry. Do you have any questions for me? Everybody is silent. There's a deafening silence. I just want to go back to a slide, and I don't know what happened to my screen. Sorry, for my murmuring. If there is no questions on that, you would see that that is basically the end of my slides. Right. I have a slide on here that deals with the practice of law. Right. And I just want to leave you with this, seeing that I'm going to leave you now. So you will find, and now I can't read it because you will find that physical attributes are not important, where the battle is one of intellect, right? Intellect, voice, personality are all weapons in one's armory, but to none can be ascribed any degree of importance. There is, however, one quality that can overcome any physical failing, and fortunately, it is a quality that each and every one of us have, and that is the quality of being conscientious and diligent. Now, this was a statement made by E. Morris in Technique in Litigation in 1969. And I just want to leave you with that you can be as good as you want to be a lawyer. You must just be prepared, know the facts of the case, know the law, and when you go to court, be prepared. irrespective of who's going to be your opponent, if it's going to be much senior attorneys who's going to stand against you, if you know the facts of your case and if you know the law, then you can't go wrong. Yes, voice, personality, and all of that can help you, but that is not so important. The most important thing is that you are prepared, you're conscientious, you're diligent, you've looked at everything. And also remember that you are only as good as your last case, and you're not going to win each and every case. Some cases are just unwinnable. We all know that. Some cases, the facts is against you, and no matter how good you are, it's just going to be unwinnable. And sometimes you surprise yourself and you win cases which you thought you couldn't win. So it's all in the game, and you're as good as your last case. And when you make mistakes, which you will make, everybody makes mistakes. In court, you will say something wrong. Don't live there. Don't define yourself by that mistakes. Move on. Learn from it and move on and do better, because the next time you will know better. That is, yeah, that is all I can say. And I have respect for your opponents, for everybody that you work with. Remember, this is just one case that you're doing, and don't get personally involved in the fights of your clients and fight with your colleague because of that. Don't insult your colleague. Remember, you're going to still do cases against each other again after that, and then that client is long and forgotten. So you don't want to burn bridges because of one client. Be respectful at all times, but do the best for your client. Yeah. So I'm at the end. If there's no questions, then that is that for High Court practice. Yeah.
Thank you for the wise word, Advocate.
Thank you, Advocate.
Thank you very much.
Okay.
I have a
Fine.
question, Councillor.
Yes, ask.
Okay, on page 227, I see that there is a question that says we must explain Rule 46. And I also see Rule 46A. Is there a difference?
Yes, 46 is the one that tells about execution of immovable property, and 46A, execution against residential immovable property. That is the new one that came into operation in 2017, where you can't just have residential immovable property declared executable. There's certain procedures that you must follow, and you must bring an application to have it declared executable. That means to be sold. Okay. So 46 deals with immovable property, the execution of that. And then you've got if it's a residential property that you want to be sold, when people are living in it, their right to housing, remember that's a constitutional right in the Bill of Rights. If that is going to be affected, then you have to follow 46A, the procedures, and you have to bring an application.
Okay, all right. Thank you so much.
Okay, Gideon.
Can I ask a question, ma'am?
Yes.
Yes, I don't know, maybe I could be putting you on the spot, for you to comment against your fellow council colleague, Advocate Defo. What do you think are the prospects of the LPC succeeding in having him removed from the role?
Oh, I look. Well, what we don't know the facts, all the facts. We just know what we read in the newspapers, and we didn't hear his side yet. So I think depending on what he's going to say, that is going to have an effect on the outcome. Yeah, I'm taking the safe route here.
I can see that, because what is strange is that you see somebody who holds that office of an advocate. Now you see the machinations in court. It's no longer about the defendants, but it's about him, which is unfortunate.
Sad. Yeah, that's sad, because it's not supposed to be about him. Yeah.
Thank you.
Okay. Yes, is another question?
Yes, ma'am.
Yes.
Yes, ask.
I would like you to distinguish between the
Advocate.
Okay, there's two people speaking. Okay, let the lady go first. Let's be, it's Women's Month. Yes, ma'am.
Thank you. Can you please distinguish between the writ of execution and the security for cost? And can one use execution in securing cost?
A writ of execution is when you have a final judgment and you now want that judgment debt to be satisfied. You want the judgment debt to be paid. Then you issue a writ of execution that the sheriff takes, and he now says, I'm coming to collect on behalf of this judgment creditor, on behalf of the person whom this money is owed. That is the writ of execution. Security for costs is when somebody institutes proceedings against you, and they are a peregrinus or an insolvent, or the proceedings is vexatious, and you say, before I defend, you must give security for the costs of this matter, because if I'm going to defend this successfully, you may not be able to pay my costs. What was your other question?
Okay, madam, I just want to check with you if you'll be able to upload these slides on the e-leader for.
Yes, it's going to be made available. Yes.
Okay.
Like I said, a disclaimer. It is
Okay,
my slides.
Other
There's
question
mistakes
was,
on it.
can one use execution in securing costs?
No. If the person don't pay within a reasonable time, if the person against whom the security cost notice was served, can you hear me?
My network is so...
Can you hear me? I can hear you. If the person does not pay security within a reasonable time, then the defendant who has served the security notice can go back to court and have the pleading set aside, the whole case set aside. That's what happens. So you don't execute on security for costs. Did you hear me? Can people hear me? Apart from Emily.
Yes, I can, ma'am.
Yes, okay.
Yes, we can hear you.
Okay, fine. I think I've answered her. Is there other questions? Gideon.
One last question from me, ma'am.
Yes.
Tell me, ma'am, I know we didn't cover this. With regards to small claims court, if a summons has been issued and the defendant does not appear, does the small claims court issue default judgment
Yes,
on that particular day?
They could. If it's damages, then you have to obviously first lead evidence to the damages, but they could.
Thank you.
Yes. Any other questions? Okay, then I have nothing more to say. It's been a pleasure engaging with you every night. Some challenging questions. Yes. And I enjoyed myself. Thank you.
And so did we. Thank you so much. And thanks for the interactive sessions. Appreciate it. Thank you so much.
Thank you.
Thank you.
Good luck. Thanks, Advocate. Thanks so much. Bye-bye.
Thanks. Bye.
Bye-bye.
Thank you very much, Advocate.
Bye, Advocate. Thank
Okay,
you.
bye. Thank you. Bye.
Thank you, Advocate. Thank you very much.
Thanks. Thank you.
Yes, I did. Thank you.